Good morning. In the previous lecture, we have seen section 14 and section 17. Today, we are going to see section 15 and 16. Okay, what is section 15? It is an act of a judge. Act of a judge who is acting judicially. He is acting in good faith. Taking into consideration the evidence before him, he has given a judgment. He has passed an order. But that order is wrong order. But he has given that order in a good faith. Then the concerned judge will not be liable. This section 15, is protecting a proper judge, a good judge, an uncorrupt judge. This section is not going to protect the corrupt judges. Got it? Nothing is an offense which is done by a judge while acting judicially in the exercise of any power which is done in good faith and he believes to be given to him by law. Means the powers which are given to him, he believes that the powers are given to him by law. He passes an order, he passes the order in good faith, but that order is wrong. It may be wrong, it can be rectified in appeal and all, but the concerned judge will not be liable. Nothing is an offense which is done by a judge when he acts judicially in good faith in exercise of his powers. This is section 15, a simple section. Judicial acts are protected. Now section 16. Now when a judge has passed an order which he considers it to be lawful, and as per the order the lower officers are implementing the order. While implementing the order, they are also protected. Means act done in accordance to the judgment or order by the court. Act done in accordance to judgment or order of the court. When these officers are also just executing, they are just implementing, they are also doing in good faith. They believe that the concerned court which had jurisdiction or has jurisdiction and we are just executing their orders, therefore they are not liable. Section 15 and section 16 are connected to each other. Section 15 is telling act done by a judge acting judicially in good faith within the powers. It is not an offense. Section 16 is telling the order or the judgment which has been given by the judge that is being executed by the officers, and they believe that the concerned judge was having jurisdiction. That judgment or the order is in force. Therefore, those officers are not liable. Nothing is an offense. This is section 15 and 16. Okay. The previous section 17 we have already seen in the first lecture, because section 14 and section 17 were connected to each other. Therefore, we saw these two sections in the first lecture of general exception, and today we are seeing, or we have seen, 15 and 16. Therefore, we will go further. That is section 18. Section 18 states about accident. What is an accident? Something unexpectedly happened, which is also a misfortune. Then nothing is an offense which is done or which happens because of an accident, done by an accident or a misfortune, without any criminal intention or knowledge, in doing what? A lawful act, in a lawful manner, by lawful means, and by taking proper care and caution. We'll see the section first. Nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge. Means there is no intention, there is no knowledge, and in doing a lawful act in a lawful manner, by a lawful means, and by taking proper care and caution, then that is just an accident. Therefore, no offense. Such a type of defense is also there in tort, and we call it as inevitable accident. Means I did my best, I tried my best, but it happened. It was outside my control. Similar here also, the concerned person has taken proper care, he has taken proper caution, he is doing a lawful act in a lawful manner by lawful means, without any intention, without knowledge, and the thing happened. then law says it is just an accident. We'll take first an example, then we'll again see the essentials. A person is there, a woodcutter is there, he is having his hatchet. He has seen whether the hatchet is proper or not, whether the blade of the hatchet is proper or not. He has checked it, means he has taken proper care, proper caution. And now he is cutting the log, he is cutting the wood. When he is doing his work, what happens? The head flies. The head flies and one person is standing nearby. The blade, the head goes and cuts his throat. Poor person, he was standing at that particular point at that particular time, and the head flies and cuts his throat. Here the woodcutter is not liable. The woodcutter will not be liable because he was doing a lawful act. By lawful means he had taken proper care and caution. The concerned person who died, he was at a wrong place and at a wrong time, and therefore the woodcutter will not be liable. Got it? That is section 18. We'll just revise it. And nothing is an offense which is done in an accident or a misfortune, which a person does without any intention or knowledge. Here also the woodcutter was not having any intention, not having any knowledge. He had taken proper care and caution, and he was doing a lawful act by lawful means and in a lawful manner. Therefore, if a defense is taken by an advocate that his client, that is the accused person, that he has done it in an accident, means in a lawful manner and all, he had taken proper care and caution, and there was no intention, there was no knowledge, then he will be exempted. He will not be liable. Got it? Okay. Bye bye. We'll see in the next lecture the further defenses or the other general exceptions.